She has tremendous knowledge of title and what goes on behind the scenes. And she is an excellent resource for me. I'm super lucky to have her on my team. She's available to do classes like this, and she's also made herself available to any of you if you have questions throughout the day and you can't get a hold of John Fernando or you can't get a hold of me to get to her, you can call her directly. So she's made herself available to do that. And today she's talking about divorce drama in a real estate transaction and how to navigate through that. I forgot to mention also that Tracey is the only field title officer out there in the industry. Orange Coast Title is the only one that has a field TO, so we're really lucky to have her. So that's all I have, Tracey, if you want to.
Okay, well, I'd say let's go ahead and start then. And I'll keep an eye on the waiting room. Lisa, if we have anybody else joining, just give me a heads up. But I do typically hear as they join in. So good morning. I am really happy to be able to give you all information today relating to this topic. As Lisa said, I am always here for all of you as your field title officer. You've got a great rep. Lisa, of course, so much experience that she brings and great business partnership. I know that she's really so well connected to all of you, and there's such a great relationship already. I'm just an extra layer of customer service that you have available to you, and I really enjoy being there for all of you as well. So reach out if you ever need me anytime. I'm here. The topic that we are covering today, the avoiding or navigating divorce drama in a transaction, I was asked to create this class actually about 1.5 years, maybe even 2 years ago, by a broker, because they had a transaction that was having some issues relating to an ongoing divorce and had lots of questions and said, that's a great topic. A lot of agents don't know too much relating to what could come up in a transaction and with a divorced couple, either previously divorced or going through divorce in the transaction. So I've created it. And since I created this presentation, this information, I've been adding. Recently, I got a few more questions from agents. So I think any scenario where there's a life experience that's happening, whether it's divorce or death of a homeowner, a growing family, for example, or empty nesters, all of these life experiences that we have, those trigger our sale transactions. So again, divorce, maybe they're going to sell. If they get married, maybe they're buying, right? Growing family, maybe they need to move to get a larger home, and those empty nesters might want to downsize. So I think it is a great topic for all of us to have some good basics on. I am not a divorce attorney for sure. You don't have to be an expert in that way. Just having some great basics is going to go a long ways. If we ever do need to get the expertise from an attorney relating to something, there typically is one that we can reach out to, especially if there was one in the middle of the transaction. The client can always reach out to their attorney for a little bit of advice to navigate. So now, why is it so important in California that we know these basics about divorce and what could happen to property specifically in a transaction? California, as I'm sure everybody knows, is a community property state. California is a community property state, which means that it's perceived that what's his is hers and what's hers is his, that they each have 50% interest in whatever assets that they have. So there's a lot of protection in the fact that we are a community property state. There's a lot of protection for the spouses in that case. So that is all the more reason why. I'll give you a first example of how it impacts us regularly. If we have a buyer who wants to buy property, and we get this a lot, we get a buyer that wants to buy property, they're married, but they don't want to buy with their spouse. They want to acquire title as a married person with their spouse not participating in any way. If that's the case and they are married, we always require that they have the spouse deed off or terminate their interest, essentially, with a spousal deed is what it's called. You'll hear that. Escrow will bring that up on occasion, that the spouse will have to formally sign a deed where they terminate any interest. If it's a grant deed specifically, which is what escrow typically will use, a grant deed versus a quitclaim deed. A grant deed terminates all interest now and in the future. So once they sign that grant deed, we don't have to be as concerned about having them sign again, let's say for a real estate transaction specifically. So we require in title insurance to call them a married person with the extra wording as his sole and separate property or as her sole and separate property. Though that wording is created, it's a formal legal vesting. Sole and separate property can only be used when the spouse is terminating that interest. And we actually call them not just a married person, married woman, married man, but married person, married man, sole and separate property, right? And what that does is it tells the public that there isn't a concern relating to once we record those documents. Of course, the public can see them. The Hall of Records records them for the public to see. And we can rely on that, the termination. Now, lenders in turn as well require the same thing. They know there is potential if they foreclose for a spouse to have an interest in a property because California is a community property state. So lenders as well require that a deed be executed to terminate that spousal interest. Now, what if somebody wants to acquire title and there's no lender and they want to acquire title with no spousal deed? They want to acquire, we can call them in title insurance, we can call them a married person. So they could acquire title as a married woman without the additional language as her sole and separate property, just her name and a married woman. So we're stating what her status is. And what we can do if she's still married, let's say, for example, but doesn't want her spouse to participate, if there's no lender making the requirement of the deed, in title insurance, we can then add an exception to the policy. We're accepting the interest of the spouse, if any. That way, we don't protect them from their spouse, but we can let them go ahead and acquire title and just simply call them a married person and show again in our policy an exception. That means they won't be covered if there is an issue relating to the interest of the spouse. So that is a way that people can acquire, and that does happen every once in a while. I've insured that way on a few occasions, been asked to do that, and we can do that. Again, we're not using that sole and separate status. So just a heads up on that. Now, the second most common scenario that we see this a lot, as a title officer, I would probably see it every week for sure. We would have a scenario where husband and wife buy property, 5 years later, fast forward, they're getting a divorce, and they have a dissolution, decree of dissolution, often ordering that one person is to get one property. If they have multiple, maybe the other person is to get a different property, and that deeds should be recorded to terminate the interest of the property that they're not going to be continuing to own. So when that happens, whenever there is a husband and wife on title and there's a divorce and there is a deed recorded, even if an attorney draws that deed, we still in title insurance have to verify the validity of it. We still have to verify and make sure that there is no money in connection, like an equalization payment. When people are going through divorce, sometimes there's an equalization payment where one is paying the other to have that property, for example, that we're in a transaction with. So if we see a deed recorded in title insurance that's not insured, that was recorded and triggered by a divorce, for example, we're going to show the effect of that deed in our prelims. And we're going to vest back to when they were both on title, husband and wife. We'll vest back. That's what you'll see as the ownership. That's what we'll show in the prelim. But the vesting will say subject to. So subject to item number, whatever the item is in the prelim, showing that transfer from husband and wife. We're going to show the effect of that deed until we can verify the validity of it. Even if an attorney assisted in drawing that, again, we want to confirm that there was no equalization payment needed, there's no money due. And all that means is that the person that came off title will sign a confirmation of conveyance. It's already printed for them. Basically, it states, if this is accurate, that they have no interest in the property any longer. They'll sign it, it'll be notarized. It's their opportunity to say if there is money due them for their agreement, their divorce. That's their opportunity to speak up. Now, on occasion, and Lisa and I probably both have had this happen. On occasion, I will have an agent call me and say, you know, our seller just went through divorce, the spouse deeded off, and now our seller is selling. And she doesn't want to go back to the spouse to ask them for a confirmation of conveyance, to join in and acknowledge that they did transfer. They have no agreement, no off-record agreement for money due them. They don't want to go back to that divorce. They're not getting along. Well, you know, we expect that because often in divorce, they're not getting along. They're getting divorced for a reason, right? Sometimes it's really amicable, but not always. And if that turns out to be the case and they really don't want to go back to that person, if there's an issue with that, we might be able to use, in lieu of a deed, we might be able to take a look at that divorce decree and see what it says. See if it says our seller was awarded the property, see if it makes any reference to any equalization, or did the other person get another property, for example. So we might be able to use that in lieu of their confirmation of having deeded off. Now, they would have to deed off if they were on title, but we won't ask for anything further if we can work with that divorce decree. I've probably done that 10, 15 times. It works certainly on many occasions. So just know that that's a possibility. That's a way to navigate some drama between the parties, right? That could be helpful to know. Now, in the case of a buyer that's buying and they want to acquire as unmarried, I have had just recently, I've got a call from an agent who said that their buyer wants to acquire as unmarried. They're going through divorce, but it looks like it's finalized, but the lender is not willing to close the transaction. They're requiring a spousal deed. And the agent couldn't understand why that was. So I said, you know, send me over that divorce decree. Let me take a look at it. Let me see when it was finalized and see if I can understand why the lender has a concern if they're truly divorced. Well, it turns out that the divorce decree was already filed. It had been filed a month or two earlier, whatever it was. It had been filed earlier in the courts. I could see the stamp. I could see it was official, the divorce decree itself. However, the date of the actual filing of the divorce decree is not the date of the divorce. So typically on those filings in the center left-hand side, they'll state a date as to when the marriage, the divorce is finalized. That's the date that we are going to be looking for. So not the date that the actual document was filed in the courts, the date that you see the stamp top right-hand corner in the courts, not that date. You look below, you'll see the date that the actual divorce is finalized. That will be in the future from that filing date, and you want to see that that's already passed to call them an unmarried person. So the good news in this case of the one that we just had recently was that it was going to be finalized in a week or two. So the agent understood. They zeroed in on that with me, that date that actually the divorce wasn't finalized. They understood, they thought it was, and they could clearly see that date on the document. They decided to wait the 2 weeks or a week and a half, whatever it was, until the divorce was finalized, and then call that person an unmarried person acquiring title. So just know that the date is different, the filing date versus the actual final date of the divorce in the future. Know that there is a difference. Now, Lisa, did you have anything that you want to add before I go on to the next scenario?
I actually do want to ask you a question.
Sure.
I have a personal friend who's actually going to go through a divorce. She's not they haven't filed yet, but he did move out of the house, and she asked me to prepare some deeds for her to take him off of title. So I prepared a grant deed from him to her, and then from her to her trust. And then she was just going to pay him, $300,000 or whatever she was going to do. But later, that's what I told her later, that later, if she ever tried to sell, title would ask for a confirmation of conveyance. So now you're saying that in some instances, we would just look at the divorce decree, and that would be sufficient?
That could be possible. So that's a case by case. Like I said, sometimes that will work. It will make sense. But you know what they could do as well, and I would recommend this, if they're going to it with their eyes open and they're being very methodical about it, like it sounds like they are, he could sign a confirmation of conveyance, have it notarized by a different notary than the notary for the grant deed, for example, and that would be helpful in the future. So it wouldn't be asked.
So just sign it ahead of time, and it's not recorded though, correct?
So the confirmation of conveyance does not get recorded, but it does refer to the grant deed that does need to be recorded. So the deed would be recorded first, the confirmation of conveyance where he states that really was me that signed it. I am due no money, or I'm due money, whatever the agreement is. And then he signs that and it's notarized. If that's notarized by a different person that notarized the grant deed that's recorded, I would rely on that. One thing to keep, does that answer the question? One thing to keep in mind though, Lisa, is that, and I've had this scenario recently brought to my attention by an agent, if one of the sellers has a judgment, an IRS lien, a state tax lien, if they have child support lien even recorded against them, remember when creditors go the extra length of recording their liens or judgments, they take them to the Hall of Records, they record them so the public can see them. The reason why they're doing that is because they're telling all of us, look here, look at my judgment, look at my lien, I want to be taken seriously and I have rights. So even if there's a divorce and one person deeds off, if a judgment or lien recorded against that person previous to their deeding off title, that will still have to be paid out of any transaction that closes. So the one that I was in the middle of recently that I got a few questions about was husband and wife were on title for about 10 years. They were married for about 15 years and they were going through divorce. He deeded to her about 6 months prior and now she was selling. And she found out during the sale that there was, I think she was aware of this, she just didn't realize it would have to be paid through her closing. There was a judgment against him and it was like $15,000 or something. It was substantial. It was a judgment against him that recorded a few years prior to him deeding off. Well, that creditor has rights that recorded that judgment. So out of her proceeds when she goes to sell, even though she's the seller, his creditor will have to be paid because they had rights. They asserted them by recording that document prior to him deeding off title, and it does attach. And creditors are paying attention to their liens and judgment rights. I've had a few occasions where, for example, I closed a transaction and the DA's office called, the district attorney called me on a child support lien because there was a child support lien recorded against a seller. And they were aware that a property had sold. They called me and asked me, where is our funds for that lien that we recorded? We're expecting to be paid out of the proceeds. I have those funds. I was aware of them. I did see their recorded judgment and we just hadn't sent it to them yet because there was some sort of hold done for a few weeks. But anyway, ultimately they got it. The point is they were aware, they were paying attention. I had the same thing happen with the IRS. IRS called me looking for funds on a transaction where they had recorded a lien against an owner and we closed a transaction. They were aware of it. They called and said, we saw that transaction closed. In that case, they were due about $100,000. And I did see that. I did have the funds held for that and that check was on its way to them. But it reminded me they are really paying attention to those liens and judgments. So if a seller ever tells you, all of you agents, if a seller ever mentions to you that they acquired title due to divorce recently or they're in the middle of divorce, put the brakes on, ask a couple of questions, ask if it's finalized or not. If it's not finalized, when will it be finalized? Are both going to be sellers? Or what's the scenario? How do they expect it to play out? And start talking to us in title. The earlier you ask a few questions, don't be shy about it. Ask a couple questions, see what you can find out about it. A few questions will go a long way in helping to determine what can be addressed early to have a smoother closing. You can reach out to Lisa, you can reach out to me, your escrow officer, tell them as much as you know, depending on what stage you are in this. And we'll kind of take it from there. We'll let you know what else we might need, maybe some other questions to ask. Ultimately, if it's a legal issue, we may have to have them talk to their attorneys. Now, if they're really battling and they're not agreeing and things are getting really ugly, you always, in that case, and I think your broker would tell you the same, want them to reach out to attorneys and have it mediated, right? Now, I have seen a rare occasion, and I've been asked if this could be possible, and it is. I have seen a situation where a husband and wife were married, they bought a piece of property, they were on title together, one wanted to sell, one didn't, and the husband that refused to sell was no longer living in the home and had disappeared, wasn't participating. Ultimately, what the wife did is she hired an attorney, and she did get a court order where a clerk was approved in order to sign on behalf of the husband and the property was sold. So there was some scenario like that. It's been a few years, but that's the gist of what happened. Ultimately, if somebody is not participating, depending on the circumstances, depending on the case, a judge could order for a clerk to sign on behalf of the actual person, or maybe someone else to be signing on behalf of the person that's not present. A court order could be obtained for that. Now, again, I'm not an attorney, so that you want to have the client reach out to an attorney if they have a scenario like that, but I have seen that. I've actually seen that a few times. In one case, it was a little bit different. It wasn't divorce. It was somebody that the property had to be sold for money due for other issues, and a court order was issued where someone signed on their behalf. So be aware of that is possible. And another scenario that we see a lot that comes up, I've seen probably 30 or 40 times, I've seen this a whole lot, is a les pendens getting recorded or an action getting recorded. So let me explain that. If we have a person who acquires property, most of the time it is a scenario where the person has acquired as a married person, sole and separate. So their spouse is deeded off and there's just one spouse on title, and they're considering selling. Well, because there's just one spouse on title, they're considering selling, they would be the sole signer, the sole seller, right? They would get all the proceeds in that case. I have seen where the other spouse that's not on title has hired an attorney and they've recorded a notice of action, or it's called a les pendens. And they do that in order to prevent a sale from closing without their interest being considered. So they want to assert their interest. California's a community property state. Maybe even though they've recorded a deed, something has changed, they feel they have an interest in the property. And by recording a notice of action or a les pendens, by recording again that document, they've shown the public then that document. We can all see that document, that someone's asserting a right. Typically a notice of action will say the nature of the action, the reason why they're filing, and it's typically because they believe they have an interest in the property. So they're giving us a heads up. They're telling us they're going to pursue this property. They believe they have an interest. In that case, we would have to slow or stop a transaction and make certain that they're accounted for, that their attorney issues either a demand for payment, or that the attorney releases it altogether, removes it with no money due. We would want to make sure that that's addressed completely prior to closing. We take notice of action very seriously. We do not want to close a transaction where our buyer then has a seller's spouse that thinks that they can move in, or that they have an interest in the property, right, or is threatening them. So ultimately we want to address that. But that is very common for a notice of action or les pendens to be recorded by a spouse. If you ever hear anything about that, please bring that to our attention. There is a gap. We can't see a few days when a document gets recorded in title insurance. All of us can't see the public record for a few days at least, because the Hall of Records, when they record documents, not only do they record them, but they have to take a photograph of every document that they record. And in Orange and in LA County combined, there are thousands of documents getting recorded every day. I don't know if you all know this, but just LA and Orange County, every day there are thousands of documents getting recorded. And the Hall of Records has to then photograph them so we can all see them. And there's a few days delay. So if you ever hear about an action or something problematic getting recorded or a concern, bring it to our attention. We will date down the file, we'll date down the property, and see if we spot anything new. We can always do that. If you ever have a client that tells you anything is happening, we on occasion have a homeowner who may take out a deed of trust during a sale transaction as a Band-Aid to get them to the closing point. If I never mentioned something like that to you, again, or a deed recorded, bring it to our attention. We'll date down the property. We can look for deeds, new taxes, anything else that could be impacting the transaction. Now, before I go on relating to inheritance and community property, does anyone have any questions or any scenario that they want to share? Lisa, anything else that you want to share?
Not at this time.
No, okay. If you all do, by the way, just unmute yourself and jump in. I like the questions. I think they're very important. You just unmute, be loud and clear, and ask your question or share.
I forgot to say that to everybody. Tracy likes it to be interactive. So if you have questions, go ahead and just ask, and we'll take questions as she goes.
Yeah, I think it's really important to be able to ask questions to really fully understand. So I do try to open it up a little bit. I know most speakers don't do that. I really like to do that. I've been in title insurance for 36 years, and got a lot to share, so please ask if you have anything. Now, another scenario that we have that I wanted to just touch on is inheritance. What if somebody inherits property, or actually what if they inherit funds and they want to buy property? They can take those funds, or if they inherit a property itself, and the spouse is not going to be required to sign a deed. Generally speaking, we're not going to require that. So if we have parties on title, let's say there's a husband and wife on title, let's say they're in their trust, for example. This happens a lot. I have seen this many times. So it's a mom and dad on title, maybe in their trust, they pass away, and now we have the kids inheriting the property. So on occasion, you'll see the trustee, usually one of the kids is the successor trustee, will deed to the rest of them or all of them because they've inherited the property. If that's the case, if the sellers, if the owners of the property acquired the property through a death of their parents and they've inherited it, we will not require a spousal deed in that case. So just for clarity, that's the one occasion that we won't ask for the spousal deed due to inheritance. Just for clarity.
Tracey, I have a question for you.
Sure.
Would that be for, so say siblings own a property together, how would it work with their spouses?
So if siblings acquire the property together, they would still have to have spouses sign off if they're actually buying property together. But if they inherit it together, if their parents were the owners of the property and they inherit the property from their parents, regardless of if there's one child that inherits, there's only one beneficiary, maybe one child to begin with, or if there are many, whoever inherits that property, we won't require a spousal deed if they inherited the property.
Okay.
So in that case, we wouldn't.
Okay,
Yeah.
and then my other question for you was going back to the liens, how long does it take to come off, like obviously that goes on your credit report, right? How long would it take for that to be taken off?
It depends on the lien, but a minimum typically is 10 years, depending on a state lien, IRS lien, judgment, child support. The DA's office, when they record a child support lien, we're going to be looking at those liens a lot longer because that can go the lifetime of the child, right? That could be more like 18 or 20 years that we would be considering those. But typically for your average judgment, we're looking at 10 years. If we want to get really technical, I've deleted a few based on the filing date, 10 years from the filing date versus the recording date, and that could save us a few months. We can close a few months earlier. So, but generally speaking, we're talking about 10 years, Sierra.
Okay, thank you so much, Tracey.
You're welcome. And again, keep in mind, if our sellers have any judgments or liens against them, they have to be paid through the proceeds, even if they have the spouse that had the lien or judgment came off through divorce. Keep that in mind. And when your seller mentions to you that they went through divorce or they're going through divorce, you might want to mention to them pretty early on, does the spouse have any lien or judgment that we could consider early, that we could dig into early, locate it. By the way, you can call Lisa at any point, or you can call myself and tell us, I've got a transaction coming up and we think that the spouse that deeded off may have a judgment or a lien. My seller's mentioning that, or maybe they do even. Can you look for that? We are the ones that can look for it. We can check the record to see if there's any lien or judgment that needs to be paid off on the seller side. Specifically, we can check the record. When we are doing our research in title insurance, we run property and we run the individual and we run the taxes. So there's a certain format that we run the property alone, looking for anything recorded on the property, whether it's a grant deed, a loan, a HOA lien, mechanics lien. Those sorts of documents are recorded on the property specifically. So we run a certain format to look for those sorts of documents. Then we run a different, what's called our GI run, general index, looking for liens against anybody where a creditor has actually recorded their lien. So keep in mind, when I'm talking about liens and judgments, a lot of people are negotiating with their creditors and they're making payments, let's say, and those creditors never record the lien or judgment. They just negotiate between them. It's off record. Once a creditor actually takes that extra step of recording the lien or judgment, in that case, it's a record we have to, in title insurance, we will see it and we'll be able to, if it's the seller side, add it to the prelim. We can show it. We may need a statement of information, which Lisa has access to. It's in our app. The statement of information is just the seller's social. Actually, it's a lot of information on the seller side. It is kept private. Social security number, date of birth. Those are things that we use to locate liens and judgments against our sellers. Keep in mind in LA and Orange County, because the population is massive here, even the strangest, most unusual name, my name, Tracey Cully Rojas, right? Not really common name. Any name, even one that's extraordinary, we could end up finding 10 people with that same name in LA or Orange County. So we need a little bit of additional information to really zoom in on our sellers and make sure we're not showing, let's say, a child support that somebody else is. We want to make sure that we really have our party. So a statement of information is a form that helps us be certain that we've got the right party's liens and we're not showing somebody else's liens. So statement of information, I actually mentioned that in almost every class. On the seller side, it always has to be completed every time, every transaction. Some agents have started including statement of information in their seller's side package, or when they're talking to the seller after they take a listing to get that cleared early. They can look for liens and judgments. That, by the way, is one of our, that's probably the number one issue that slows the transaction. Lisa, I don't know, would you agree that slows the transaction when a seller has a lien or a judgment that didn't get talked about early or considered early, and then we find it when we get the statement of information just prior to closing, right? That'll slow our transaction, Lisa?
Right, and that's why we always talk about having everyone open a listing prelim as soon as they can and trying to get a statement of information in as soon as possible so we can clear things up before it even goes into escrow.
That's right, that's right. So that goes with any transaction, divorce or not, just any transaction. We want to make sure our seller's side, the statement of information is getting cleared as early as possible. Or take a modern approach and ask your seller, is there anything that I can help you with? Anything you want to talk about early? I know as an agent, transactions get slowed down due to liens or judgments against sellers, and it's great to talk about it early. Maybe they have something they want to disclose to you. You can tell them you ask every seller just to be on the safe side, right? And by the way, even if a client is very wealthy, we don't want to think that because they have great wealth that they wouldn't have a lien or judgment. I had a seller who had a $500,000 IRS lien, right? So it happens. They could just have larger liens, maybe in some cases, depending. So don't think that they don't need your assistance or to have that conversation. It's a great one to have early. And again, make it generic. You know, you ask everybody because you have the experience to troubleshoot early like that. It's a great thing to do. So I would say, just to recap, more than anything, keep your ears open. If you ever have a buyer or a seller that mentions that they're going through divorce, it can impact a transaction on either side, right? If the buyer is going through divorce and they want to acquire without having their spouse join in, but the divorce isn't finalized, that could be a real issue. And it could just be a matter of waiting a couple extra weeks, depending on what the divorce decree says. So we can look at those with you if you like. We're here for you. We're here to be the best business partners that we can. And, pass that information on to us. Take a couple notes, and you don't have to be experts. We're here to help walk you through it and to help navigate these divorce issues. We expect them. We do expect them. Again, they are part of a life experience that could trigger a sale, divorce, marriage, empty nester, or a growing family, right? So that's just part of what we do. And I'm glad you all were able to join us today. Lisa, anything you want to say to wrap up?
No, I just want to know if anybody else has any questions right now. Tracey is an expert, so she can help you.
Oh, and as always, we're going to make sure that you have a piece of literature as a reminder to ask those questions, to touch base, a couple things that can come up, a reminder about creditors, liens, and judgments, seller's side, the fact that California is a community property state. We take it seriously for that reason, and lenders will as well. Our spouses have rights, and we want to make sure that we address them early, talk about them early. Little communication is going to go a long ways. Any questions, anyone? Yes, Melissa. Oh, Melissa, unmute.
There you go. Can you hear me now?
Yes.
Hi, Tracey. Nice to meet you.
Hi.
I have a question regarding interspousal transfer reports. How does one deal with that? And, what are the rights when it was blindly signed, or what's the situation like for the person that is trying to get the home through a divorce?
Okay, so the first part, I didn't hear that part. Interspousal, what was it?
I think it's called an interspousal transfer.
Transfer.
Where,
Okay.
yeah, you know
So,
those.
yeah, okay. Well, let's say if somebody is on title and they're going through divorce, if they're both on title together, let's start with that. I touched on that earlier a little bit. They're both on title together and they're going through divorce. Often, if one of them wants to keep the property, if they're able to, if one of them wants to, then the court order, the divorce decree will state that one of them gets that property, the other one has to deed off, right? So if that happens and there's a court order that states that the other one is ordered to, the spouse that's not staying on title is ordered to record that deed by law. They have to have that completed. Sometimes a divorce decree will say within a certain amount of time, or that there is money due for equalization. Maybe they're deeding off, but they're getting an equalization payment, right? We want to make sure that that is done if that's the case. That's why we ask for, if a deed is recorded, we see that, we're going to ask for confirmation of that transfer for the person that came off to give us that statement that it really was them. They deeded off and that they don't have any interest, or that they are due equalization payment. It's a good time to talk about it, right, before we close. So it really does need to be done through attorneys. It is a legal process, divorce is. I would highly recommend, if they're disputing, if they need a mediator, if it's not a scenario where they've already gone through the process and a deed's recorded, maybe something you might be referring to as if they're in the process of it, right? It hasn't been finalized yet. Yep. So if they're both on title, they both need to sign everything in the sale transactions. All the documents should be signed by both if they're both actually on title to the property. If only one of them is on title to the property, then the other one may record a notice of action. We would not want to get too far into a transaction because maybe one's on title but they're married, knowing that the other one might record a notice of action. That could come up the day before closing, right? We could see that. So knowing that there is push and pull between them, and that they both are wanting the property, believe they have an interest in the property, and California is a community of property. We would highly recommend they talk to attorneys, get it mediated, work through that. Again, your broker probably would be pretty quick to tell you as well if there's any sort of disagreement between the parties, that they reach out to attorneys and work through some of those things. We might think it's okay, to proceed, but if, again, a spouse records a notice of action or a lis pendens, that's their way of stopping everything at the last minute and keeping the property from being sold without them being considered. You don't want that to happen in your transaction. So if you hear there's a problem, put the brakes on, talk to your broker, see if they can get somebody to help mediate, or the attorney can assist them in that and address it early. Again, primarily, 99% of what I talk about, whether it's trust, probate, hero, solar, you name it, we've got 14 hot topics right now. All of those hot topics, the core is you don't have to be an expert, but if you hear something that is concerning, the name of the game in real estate is disclosure, right? If somebody discloses, protect yourself. So you may not always know, and the reason why we bring these classes to you as well is so you're kind of familiar with some of the terminology. What does it mean? Notice of action, lis pendens, community property rights in property in California. We're giving you some terminology. That way, if you hear these things, you don't have to be an expert. Maybe take a couple notes and start sharing what you're hearing so you can get a little advice and some feedback so you don't go too far into a transaction and get too close to a closing date, because then it becomes really, really intense, right? If we have a problem, we have to slow or stop a transaction once we're already in escrow. Much better when you have a listing, if you have a little time, start having those conversations, be frank, be confident about it, know that that it's a good idea to do that, and you can present it as a way that you're protecting them and looking out for them, to have conversations about things that may be concerning. If they mention something, ask a couple questions. If you do that alone, if you can ask a couple questions, if you ever hear anything relating to a divorce, for example, in process, and you start sharing that with your broker and all of us, we can give you some real guidance as to what's next and what will happen potentially if it's not addressed, right? So you know going into it with your eyes wide open. And you always want to protect yourself, right? We're looking out for you, our own company, but we're looking out for you as well, and always our buyers and our lenders that are insured. We want to make sure we have a smooth closing. The more we talk about things early, the smoother closings we have, the more referral business we get, right? So we really want to do that. We really want to see you all succeed and be confident in your transaction. Know that you're not alone. So does that answer your question, Melissa?
Yeah, so far. I probably have a couple more, which I'll probably email you or call you.
Do that. Absolutely. Keep reaching out. That's what we're here for.
Yeah, thank you.
All right, Lisa, anything else? Any other questions, anyone? Okay.
Okay, well, thank you guys all for coming on, and we did record it, so if anyone asks you, we can forward it to them, because I'm sure a lot of people wanted to be on and they couldn't be. So thank you all again for everything. I appreciate all of you as well, and if you need anything at all, contact me, or if you have any further questions, contact Tracy.
Thank you, guys.
Thank
Thank
you.
you. We look forward to seeing you in the next one.
Thanks. You too.
All right. Have a good day.
You as well.
Thank you.